Welcome to day 2 of the Geometry of Redistricting workshop. It's such a pleasure to see everybody's faces here today. My name is Justin Solomon from MIT, and I'll be your guide to this morning's speakers. So without further ado, it's my pleasure to introduce Ellen Katz. She's the Ralph Eigler Professor of Law at the University of Michigan. Ellen writes and teaches about election law, civil rights and remedies, and equal protection. Her scholarship addresses many questions of minority representation, political equality, and the role of institutions in crafting and implementing anti-discrimination laws. So with that.
All right, well, thanks, Justin. Thank you. So good morning. It's terrific to be here and be part of this event. I do feel a little out of my element here, but it's wonderful to be here. I want to thank Justin and thank Moon for putting this terrific event together and including me in it. I'm going to talk about race and redistricting, and specifically the constitutional and statutory rules that govern the use of race in the redistricting process, and including the ways race may not be used in districting, and also the way race must be used in districting and the tension between those two. And I'm going to start, there are many places one could start this discussion. I'm going to start in Tuskegee, Alabama, which is where Booker T. Washington set up his famous institute in 1881. The city had a highly educated black population and in fact was majority African American up until this map that was drawn by the Alabama legislature in July of 1957. And the map was the legislature's response to increased efforts by African American residents to register to vote, and a relatively close school board election in which an African American candidate came close to winning in a racially polarized election in which virtually every eligible white voter was registered, and black voters still had lots of folks, the black population had lots of people they could add. So in July 1957, the Alabama legislature unanimously and with no debate redefined the boundaries of the city of Tuskegee, creating what Felix Frankfurter would call an uncouth 28-sided figure, which is what this map does. And you can see the Tuskegee Institute is no longer within the city limits, which was the intention. The court's opinion in the case, Frankfurter will tell us, all save 4 or 5 of the 400 black voters who were in the city at the time were removed, and not a single white voter was taken out of the city limits. This is Charles Gamillion. He was a Tuskegee professor of sociology, and he was the lead plaintiff on behalf of a group of black voters who wanted a declaratory judgment declaring the new district lines to be unconstitutional under the 14th Amendment's Equal Protection and Due Process Clause and the 15th Amendment as well. District court said, nothing we can do about this, no relief. The Court of Appeals agreed, saying that district lines, legislatures have sweeping authority to draw district boundaries. I'm just going to go back to the map. A unanimous Supreme Court reversed in a decision by Felix Frankfurter, who had or was and remained one of the court's most vocal members, speaking about the dangers of entering the political thicket and the thought that district lines are really quite untouchable. This, however, Frankfurter thought was something very different. He called what happened in Tuskegee, this is not an ordinary exercise in redistricting, he wrote, even within the familiar abuses of gerrymandering. Instead, the purpose here was to segregate white and African American voters, and he uses the word by fencing black voters out of town so as to deprive them of their pre-existing municipal vote. And he held that it was a racial gerrymander in violation of the 15th Amendment, which bars denying the right to vote on the basis of race. And I want to start with Gamillion today because we look at this map and we look at what Alabama did and we have a sense that Alabama can't do that. And whatever else one might think the Constitution prohibits, it's got to prohibit this, in a sense that the court appropriately intervened to say this is no good. At the time, however, it was not clear that that was true. I suspect when Alabama first saw that, Alabama officials saw that Felix Frankfurter had written the opinion, they thought, we won, and yet they didn't. The non-justiciability of districting lines, the notion that they're not something courts can touch or evaluate, was a huge obstacle in the case. Charles Gamillion no longer resided in Tuskegee, and no one has a right to vote in a jurisdiction where they don't live. And yet the court intervenes, and it's holding that the lines are not untouchable, that there's something courts can adjudicate and think about and hold in certain circumstances to be a violation of the Constitution, and we'll see later of the Voting Rights Act, was a huge step. It paved the way for Baker versus Carr 2 years later, in which, over Justice Frankfurter's objection, the court moves into that thicket and decides to look at malapportionment between highly populated and less populated districts, and 2 years later announces the one person, one vote doctrine in Reynolds versus Sims. The uneasiness of the court's intervention in these sorts of cases persists, and I think it is that uneasiness that continues to plague the partisan gerrymandering disputes that you're all here today to talk about and think about, in the sense that there is something deeply activist, untethered about judicial involvement in this realm. I'm also starting with Gamillion for a second reason, which is how the case is remembered and used in later litigation. My talk is going to be largely chronological. And by the 1990s, and I'll talk about this in a little bit, plaintiffs begin challenging majority-minority districts and the concentration of initially African-American voters in majority districts pursuant to the, in districts that were drawn pursuant to the Voting Rights Act. And when they start bringing these claims, they say that these districts and the aggregation of voters, the deliberate concentration of voters in them resembles Gamillion, and in fact is just like Gamillion and just like what Alabama did at that time. And a series of decisions will honor that analogy or agree with it. And it continues to be the case that many people do view majority-minority districts drawn ostensibly to comply with the Voting Rights Act as analogous to what Alabama did in Tuskegee in 1957. Gamillion, of course, is the beginning or part of an initial attack on the Jim Crow regime, in which the court plays a huge role. Brown versus the Board of Education is a few years earlier, efforts to desegregate all sorts of public institutions. But it wasn't the court was not the only actor, and there were, needless to say, protests on the ground. The Montgomery bus boycott, which prompted Congress in 1957 to enact the first civil rights statute that it had enacted since Reconstruction. Senator Lyndon Baines Johnson pushes through the act in the Senate. It's a modest measure. It empowers the Attorney General to bring injunctive voting suits. It gives rise to this apparatus that sets up the Civil Rights Division in the Justice Department. It's followed in 1960 by another statute that expands some powers, adds record-keeping requirements and other provisions that prompts the Justice Department to begin bringing voting rights suits. And these are time-consuming lawsuits, and they yield hard-fought victories. But it turns out the victories are yielding little progress on voting rights because jurisdictions finding their discriminatory practice is held to be discriminatory simply replace it with a new discriminatory practice, and new litigation needs to be brought to address it. These are some numbers from the, I don't know if you can see it, that was part of the record in the 1965 Voting Rights Act. And if you can see, these are some voter registration numbers broken down by race. Dallas County is where Selma, Alabama is. And if you look here at the numbers, approximately 71% of white voters are registered to vote. And I can't see the numbers. Am I on the wrong line? Yes, I'm on the wrong line, 66. And only 2.2% of black voters are registered. You could look at the bottom, we have 0 black voters registered in Wilcox County, and then under the white voters, there's a couple places where more than 100% of the white voters are registered. This is the state of voter registration in the early 1960s in Alabama. I'm gonna now show you slides that I should have talked to Kristen about because I know she showed you these. This is a very young John Lewis crossing the Edmund Pettus Bridge, and these are familiar slides to you about the protests in Selma, Alabama, and the confrontation with Alabama state troopers on the bridge. And then, of course, the march that follows to Montgomery after those protests. That march and those protests prompt Lyndon Johnson to call on Congress to enact voting rights legislation. He gives this very famous speech in which he invokes the language of the civil rights protesters, talking about how it is that their cause must be our cause, and it's all of us who must overcome the crippling legacy of bigotry and injustice. And Johnson, to the horror of some of the Southern congressmen, we shall overcome, he pledged. And Congress responds with the Voting Rights Act of 1965, often labeled the crown jewel of the civil rights legislation. And what it does is it subjects specific jurisdictions with a history of discrimination to additional provisions. And the notable features of the Voting Rights Act of 1965 was the manner at which targeted those jurisdictions that used, in the formula that was put in place in 4B, jurisdictions that used a test or device and then initially on November 1st, 1964, had fewer than 50% of their eligible voters registered or actually participating in the 1964 presidential election. So test or device, very low levels of voter participation, made a jurisdiction a covered jurisdiction within the meaning of the statute, and that meant that the jurisdiction could no longer use its test and device, and critically had to obtain something called preclearance. Again, I'm sure Kristen discussed this. Federal approval from either a federal court in DC or from the Civil Rights Division, the Attorney General, and the Justice Department, confirming that a proposed change to election law would not be discriminatory in purpose and effect. This map is not from 1965. The dark purple are the places that were initially covered by the Voting Rights Act of 65 rather, based on the 64 trigger. Congress is going to amend the statute in 1970 and again in 1975, and each time the Congress does it, it adopts a new trigger date using elections in 1968 and 72 and gauging political registration on those dates. What also expands coverage, the lighter purple are the jurisdictions that are added later. A test or device becomes defined, sorry, do I have it? A test or device is use of an English-only ballot, in which 5% of the population speaks a language other than English, which also expanded the reach of the statute. The orange jurisdictions are jurisdictions that bailed out, which were separate provisions of the Voting Rights Act that allowed jurisdictions with clean records to say, we've been good, we've behaved, we ought not to be subject to this anymore. The preclearance requirement, the guts of the Voting Rights Act, was really a huge innovation and an intrusive remedy, because it displaced the traditional or the standard presumption that administrative and legislative action is legal until proven otherwise. And what the Voting Rights Act did was shift that presumption and said, you jurisdictions have behaved so badly and engaged in such discrimination for so long, we're going to presume everything you do going forward is no good until you come forward and prove to federal authorities that it's non-discriminatory. The Warren Court upholds it as an innovative, inventive remedy, and that Congress could lawfully choose to shift the advantage of time and inertia from the perpetrators of evil to its victims. The court would also pledge to give the Voting Rights Act its broadest possible scope, and in thinking about what changes are subject to preclearance, what sort of changes to electoral rules need federal approval, the Warren Court said pretty much everything. And one of the big moves in the first case was the move from a districted election to an at-large election, and that was a change with respect to voting for which preclearance was required. Justice Harlan is going to dissent when the court says that, saying, no, the Voting Rights Act should be about devices, literacy tests, things like that, not district lines. But he loses that fight, and the statute applies to lines and to redistricting thereafter. The 65 Act is amazingly effective. Black registration goes up almost immediately, and by 1970, we begin seeing federal judges adjudicating cases saying things like that Black voters were registering and voting, quote, without hindrance, which is a remarkable thing given the scope of where we started on this. But with increased Black participation or minority participation, there became a realization that meaningful participation in the political process required more than simply freely casting a ballot, and that the lines in which that aggregated votes had to be a part of that. And so it began with disputes about the relationship between at-large elections to districted and then among different types of districts and where the lines go. And the doctrine of racial vote dilution develops first under the Constitution and then under the Voting Rights Act here's where my boring slides begin. This is Justice White. I have a whole bunch of just pictures of justices. My students complain that I should have better slides. But in any event, this is Justice White, who you're going to look at for a couple minutes now, who wrote two pivotal opinions in the early 1970s, articulating the contours of the racial vote dilution doctrine. The first case is Whitcomb versus Chavez in 1971, which is a case brought by African-American voters in Indianapolis, challenging an at-large election system. And their claim was that with single-member districts, they would be able to elect somebody. But because they were in multi-member districts, they have less responsive legislatures, and that the present system allows almost no political force or control over legislatures, and that their vote is canceled out. And what Justice White says in Whitcomb is, you know, that's the kind of claim we can hear. The Equal Protection Clause, we can figure that kind of claim out. You're not surprised Justice Harlan is complaining. No, that makes no sense. That's not the kind of claim courts can adjudicate. It makes no sense to talk about a minority group's vote being canceled out in a majoritarian system. But Harlan has lost this fight before. He loses it on one person, one vote. He keeps losing it. But here Justice White says, we're open for business for these kinds of claims. At the same time, he says, plaintiffs, you lose. You lose in Indianapolis because I don't think there's anything going wrong here. Whatever racial vote dilution means, and here's his language, which I can't see, it does not mean that any group, says Justice White, with distinctive interests must be represented in legislative halls if it is to be numerous enough to command at least one seat and represent a majority living in an area sufficiently compact to constitute a single-member district. Just because you can draw a majority-minority district doesn't mean you have to under the Equal Protection Clause. This is what Justice White said. There's no indication that the lines here were drawn with the intent to discriminate on the basis of race. Sure, there's nothing close to proportional representation, but no one is entitled to this, and he notes that black voters in Indianapolis register and vote. There's a slating organization. The Democratic Party is actually receptive to their interest. It's just that Democrats are losing, and that doesn't state a claim under the Equal Protection Clause. 2 years later, a case called White versus Register, Justice White, for unanimous court, says that the reliance on multi-member districts in two counties in Texas violates the Equal Protection Clause. And here he's very clear that not every multi-member district is going to be the problem, but sometimes they will deny an equal opportunity to participate and elect. And the language that becomes Section 2 of the Voting Rights Act is now being spelled out in White versus Register. And Justice White tells us that plaintiffs must produce evidence to support findings that the political processes leading to the nomination and election were not equally open to participation by the group in question, in that its members had less opportunity than did other residents to participate in the political process and elect legislators of choice. And he looks in Dallas County, Texas, and he finds all sorts of factors that contribute to this finding: a history of official discrimination, a majoritarian system that uses a place system, a white-controlled slating organization that kept the black population in Dallas out of the slating of candidates, racial tactics in campaigns, a lack of minority officials ever elected, and the lack of responsiveness by those who are elected. He looks to Bexar County, Texas, where there's a Mexican-American population, and adds socioeconomic and cultural factors that hinder political participation. The factors that Justice White talks about are cited and distilled in a case called Zimmer in the Fifth Circuit a few months after White versus Register, and becomes known as the Zimmer factors for thinking about racial vote dilution, unresponsiveness of legislatures, a tenuous state policy, and existence of past discrimination. No one factor is critical or dispositive, and it's a very fluid, multi-factor test for thinking about it. What happens then is 1980, this decision called Mobile versus Bolden, in which the Supreme Court looks at a racial vote dilution claim brought by black voters in Mobile. At the time, black voters were approximately 30% of the city's population. There's a three-person city commission that's governing the city. Black voters are never electing a representative to the commission because it's an at-large system in which candidates run from numbered posts in staggered terms. It's a very common way to elect city governments at the time. Thousands of municipalities are using it. And it's a vote dilution claim. The plaintiffs come in, and here's another justice photo. There's Justice Stewart. And he says, there's nothing wrong with the Mobile system. The only thing that could make the Mobile system a problem was evidence that city officials adopted the at-large electoral scheme for the purpose of discriminating against minority voters. They need to have the intent in drawing the line and deciding to use the at-large structure. And all the other evidence of the district court that the plaintiffs thought was relevant didn't matter. Yes, there's a history of discrimination. We're in Alabama. There's going to be that in every case. Yes, black people were never elected to the commission, but there's no obstacle to their running. Sure, the commission engages in affirmative discrimination in employment, go sue the commission if you are unhappy about that, and so on and so forth. Every one of the factors he clicks off and says none of that is sufficient to prove a violation of the Constitution based on racial vote dilution. Here's Thurgood Marshall, who dissents in the case, trying to fighting a fight that he already lost in 1977 when the Supreme Court held that the 14th Amendment is not violated by practices that have racially disparate impacts, but in fact need to have racially discriminatory intent. Washington versus Davis, that 1977 decision, involved an employment test that had a racially disparate impact, no violation unless the test was adopted for the purpose of having a racially disparate impact. Here, it's structurally the same argument. Marshall presses the claim that this is voting, and voting is different than an employment test, and we should have a different standard. I thought we were wrong in 77, but we should have a different standard when we're talking about the right to vote, either by allowing impact to be enough or to use a less narrow conception of intent. Mobile versus Bolden is followed by the 1982 amendments to the Voting Rights Act, where Congress responds to what Mobile did by saying, okay, fine, we're going to amend Section 2 of the Voting Rights Act, which previously was thought to be coextensive with the 15th Amendment, to have it do something else, and basically to have a results-based test for discrimination. This is President Reagan signing it. Don't have time for it now. There's a fascinating political process story about how Ronald Reagan is signing the 1982 amendments, race-conscious, intrusive amendments to the Voting Rights Act. A similar story that can be told in 2006, when George Bush signs the 2006 reauthorization and the political process that mobilizes behind it. The 1982 amendments add this language to Section 2. It prescribes any voting practice that results, and that's the key word, results in a denial or abridgment of the right to vote on the basis of race or membership in certain language minority communities. It's not a pure disparate impact test, but it mandates a complex inquiry from White versus Register and the Zimmer factors defining racial vote dilution. No single factor is dispositive, and Congress adds this notion that another thing you ought to consider is the scope of racially polarized voting, and that is a factor that will contribute to a violation. At the same time, Congress also says, whatever else this statute we just wrote meant, it does not mean anyone has a right to proportional representation. This is Ralph Jingles, who becomes, as a judge. Before he became a judge in North Carolina, he was the lead plaintiff in the case Thornburg versus Jingles, in which the Supreme Court first grapples with the 1982 amendments to the Voting Rights Act and the multi-factor test and how courts should be dealing with them. There was a lot of disagreement in the lower courts on what should be done. It's a challenge to a North Carolina redistricting plan. There were several districts were challenged. Most of them were multi-member districts. And so here, I don't know, I like this portrait of Justice Brennan instead of a photograph. Justice Brennan gets the case and for the court says, let me give you some guidance on how to figure out this multi-factored, complicated test under Section 2. And seeking to clarify the circumstances in which Section 2 liability might arise, he distills three preconditions to a Section 2 claim: that the plaintiffs are, the minority group is sufficiently large and geographically compact enough to constitute a majority in a single member district, that the minority group votes cohesively, and that the white majority votes cohesively against the interests of the minority group. These are the Jingles factors. They play a role in all the cases that come after. Whether they were mandated by Congress is highly debatable. Here's Justice O'Connor, who thinks they were not mandated by Congress and objects strenuously to Justice Brennan's distillation of the three factors. And she notes the tension between what Section 2 of the Voting Rights Act is trying to do and what it's trying to prevent, namely or trying to avoid proportional representation, trying to protect an equal opportunity to participate. And she thinks Brennan's three factors give too much weight to the ability to elect and too much weight to something that's going to devolve into proportional representation. And she says in her opinion in Jingles, she says, we've rejected the proposition that any group with distinctive interests must be represented in legislative halls if it's numerous enough to command at least one seat and represents a majority living in an area sufficiently compact to constitute a single-member district. And that language should already sound familiar because that's the language Justice White used back in Whitcomb in saying whatever racial vote dilution is, it's not that. And I always kind of see her leaning across the bench. You kind of hear Justice O'Connor's gravelly voice looking over to Justice White saying, what are you doing? Why are you signing on? But he signs on and the Jingles factors become law. Her concerns that they were going to devolve into a mandate for proportional representation through the creation of majority-minority districts persists, and it continues, it gathers force, and I will talk in a moment about other justices and how the law comes to be shaped by the concerns that she voiced in 1987. Before doing so, I just want to point out sort of wrinkles about Jingles that are worth remembering. The first being that the Jingles test did not mandate the creation of majority-minority districts. That what the Jingles test actually did was describe circumstances that would give rise to liability under Section 2. It didn't talk about remedy at all. And I think that's important to remember because as time goes on and as justices, other federal judges, litigants of various stripes feel that these districts are deep problems, the court forgets that Jingles didn't mandate that remedy and starts to think about ways to narrow the Voting Rights Act rather than to think more creatively about remedies that might be put into place. Without a doubt, Jingles invites the creation of majority-minority districts both to remedy Section 2 violations and to avoid Section 2 violations, to create them prophylactically. They were also created under Section 5. For a time, violations of Section 2 were viewed to be reasons to deny preclearance under Section 5. The Justice Department also pushed back on plans that didn't create sufficient numbers of majority-minority districts. And just one other word on this. It's worth also keeping in mind, I'll just say this of my view, I have many others' views as well, that the majority-minority district was a very powerful remedy for vote dilution and remains one, even as it's highly contested. It enables communities of color to get a seat at the table. It changed the face of representation in the United States, and as a result of Jingles, as districting plans began to include more and more majority-minority districts, voters in those districts elected not exclusively, but very often minority representatives. And by the mid-1990s, there were minority representatives serving on school boards, city councils, state legislatures, and in the US House of Representatives in numbers that had not been seen since Reconstruction. And in many cases, the candidate came forward, the first African-American candidate since Reconstruction to run from this jurisdiction, to win in this jurisdiction. But the proliferation of majority-minority districts raised concerns for lots of people, and in particular for the Rehnquist court, which was uneasy about their proliferation and the type of political participation the court thought it generated. And the Rehnquist court in the 1990s began to pursue a steady and determined project to rein in the regime and restrict the use of the majority-minority district. And it did so in two ways. The first was it read the Voting Rights Act narrowly whenever it could. There are lots of examples of this. I'm going to give two more justice pictures. Here's Justice Thomas. The case is called Holder versus Hall. This is a challenge from black voters in Bleckley County, Georgia. They're 20% of the population, but Bleckley County, Georgia is governed by a one-person form of government. And what the plaintiffs in Holder said, well, look, if instead of having one representative, we had 5 representatives, you could draw a district, we could elect somebody to the city commission. And this is a kind of governing structure that's used throughout Georgia. Why not use it here in Bleckley County? Justice Kennedy for the court is going to say, no. Section 2 is not about that. We don't have a basis to say how big your government should be, how many people it should be. It doesn't reach that. Justice Thomas famously concurs in that case. He says, yes, that's all well and good, but let me tell you something else that's wrong. What's wrong is racial vote dilution. That is not a thing. That is not a thing that should have been cognizable. Under the Voting Rights Act from the beginning, we made an error. This is political theory, not law, and it is a bad political theory where we have sanctioned the deliberate creation of segregated districts. It's led to the balkanization of the country based on the invidious premise that voters of the same race think alike. And at that moment, he says, I'm not going to recognize racial vote dilution ever in any case and recognize Section 2 to cover that. Justice Scalia signs on with him to that opinion, and they will dissent or concur from any other decision thereafter that has a racial vote dilution component. Same day as, here's Justice Souter, same day as Holder versus Hall, the court decides Johnson versus DeGrande, in which Justice Souter puts forward a competing vision of the majority-minority district. And I'll call it an embrace, although it is certainly qualified and not unequivocal, but it is a more sympathetic version of the majority-minority district. This is a lawsuit out of Florida challenging a districting plan in which both African-American and Hispanic voters claim more majority-minority districts could have been drawn, and Florida didn't draw enough of them. We're not talking about at-large structures, just the raw number of districts. And Justice Souter says, not so. Yes, they could have drawn more, but there's no violation of Section 2 by their failure to do so because the number of districts they drew achieved something, and he uses this word proportionality, meaning the number of majority-minority districts was roughly proportional to the populations at issue, and that's enough. One, he says, may suspect racial vote dilution from political famine, but one is not entitled to suspect, much less infer dilution by a mere failure to guarantee a political feast, which is a Justice Souter kind of sentence. What he says, though, is that, look, I don't want people reflexively drawing majority-minority districts. Section 2 is a multi-factored, not a rigid, not a bright line test. And I want there to be analysis because Congress told us there should be contextual local appraisals. And the reason we shouldn't have too many of these is because of the following. Majority-minority districts, he tells us, are second-best solutions, and that racial and ethnic cleavages sometimes necessitate them to ensure equal opportunity, but don't let that obscure the fact that in some communities allow for coalitions, and that majority groups don't need to be the majority in a single-member district. Maybe the candidate elected won't be the perfect candidate, but minority voters are not immune from the obligation to pull, haul, and trade to find common political ground, a virtue that's not to be slighted in a statute that's meant to hasten the waning of racism. I've always liked the pull, haul, and trade image as capturing the essence of what voting is. This is the embrace of the majority-minority district, and you might say that's not much of an embrace. It's certainly an equivocal, a resigned, yes, we need them, but let's try and produce systems where we don't need them and use them cautiously. And that's where the court is on the majority-minority district in the early 1990s. I said the Rehnquist court did two things to curb use of majority-minority districts. The first is this, making the Voting Rights Act more narrow. And the second is the racial gerrymandering cases that I alluded to right at the beginning when we were talking about Gomillion. And so the court announced, created, made up a new injury under the Constitution, an analytically distinct cause of action stemming from when jurisdictions create oddly shaped majority-minority districts that are not absolutely required by the Voting Rights Act. And it was this constitutional injury that blunted the incentive to create more majority-minority districts. This is a map from Shaw versus Reno, the North Carolina case in that led a whole series of cases that are the Shaw cases. North Carolina in 1990 is about 20% African-American, but it's a dispersed African-American population constituting a majority in just 5 of the state's 100 counties. Subject to preclearance as a covered jurisdiction, North Carolina submits a plan that contains 1 majority-minority district. The Attorney General says, no, I won't preclear that, draw another one. North Carolina didn't want to draw the district that the Justice Department wanted to do, so it drew District 12. District 1 and 12 are the ones that are contested in the case. For what it's worth, the Wall Street Journal described District 1 as an ink blot, a bug splattered on a windshield. District 12 runs along the I-85 corridor dividing counties, towns, drivers on the highway are sometimes in different districts as they're driving along it. White voters sue, challenging this as a racial gerrymander, not a vote dilution claim. Not that white people don't have enough representation in the state of North Carolina, but that these lines are causing a distinct kind of harm. And Justice O'Connor, writing for the court, is saying, you bet, these lines do seem to cause a problem. Not that all race-conscious districting is actionable in all circumstances, but that when a plan is so irregular on its face, it has to be rationally viewed only as an effort to segregate the races without regard to traditional districting principles and without a sufficiently compelling justification. That, O'Connor tells us, states a claim for which relief can be granted. And then she goes on to say, it is unsettling how closely North Carolina's plan, this plan, resembles the most egregious gerrymanders of the past, and her citation there is to Gomillion. Here's another picture just of the district. And she sees an analogy. What North Carolina does in the 1990s, ostensibly to comply with the Voting Rights Act at the behest of the Justice Department, albeit not with these lines. But that move is no different than what Alabama did in 1957 when it threw every black voter out of the city of Tuskegee. Appearances matter, she tells us. Linking people by only the color of their skin, they may be separated by geographical and political boundaries and have little in common. This resembles political apartheid, and that's her language. It was language that Justice Thomas also uses in Holder. The Shaw injury comes to be understood as an expressive injury, and you can decide for yourself whether you think that's really a thing. That the message that a jurisdiction sends by relying on race in particular ways in the districting process hurts voters regardless of race as individuals in a way that violates the Equal Protection Clause. The court is going to struggle with this doctrine throughout the 1990s. Hundreds and hundreds of pages in US reports is devoted to trying to figure out what this injury is. It's distilled down to the test that if race predominates over traditional districting principles, the state needs a compelling justification. The court will apply strict scrutiny, will look very hard at the lines, and the state needs to come forward with a compelling justification. Not just a legitimate justification, but a really good justification. And even then, the line that's drawn has to be narrowly tailored to advance that really good justification. If you piece together different opinions, Justice O'Connor concurring with herself in one particular opinion and the four so-called liberal justices at the time, compliance with the Voting Rights Act comes to be recognized as a compelling interest. But in none of the Shaw cases are the maps viewed or understood to be required by the Voting Rights Act, so they fail under the strict scrutiny that the court applies. Come 2000 and the redistricting process that starts then, there's a serious concern that the Shaw cases present for redistrictors. How do you draw district lines that on the one hand comply with the jurisdiction's obligations under the Voting Rights Act, under Section 2 and in places where Section 5 applies? How do you do that and at the same time not engage in racial gerrymandering in violation of the Shaw cases? And two things happen that sort of shape that debate as the 2000s begin. And the first is the final of the Shaw versus Reno case is a case called Cromartie, decided in 2001, still trying to find a districting plan for North Carolina in the 1990s, in which the court observes that lots of district lines where race and party are tightly correlated might look like race is predominating, but it might actually instead be that the districtors were going after party. And a place like North Carolina, where African American voters are reliable Democratic voters, a line like this, when it's a different line by the time it gets to Cromartie, might be explained by reasons of partisanship. And where that is true, race doesn't predominate, strict scrutiny is not required. So what Cromartie told districtors was, say party, not race. We're just looking for Democrats, and that's why we drew the line that we drew. We weren't looking for African American voters, race didn't predominate. So it invited more brazen invocations of partisanship in the districting process. Another thing that happened in the early 2000s was the Democratic Party recognized that the concentration of black voters, minority voters more generally, into single-member districts did not always devolve to the benefit of the Democratic Party. And particularly in places like Georgia, where the Democratic Party was having a numbers problem, the Democratic Party understood itself to benefit by unpacking majority-minority districts where minority voters would form coalitions with white Democratic voters to elect Democrats and are ostensibly candidates of choice of the minority community without the minority community being a majority in the district. Georgia versus Ashcroft, which I don't have time to go into in very much detail, but I'll just flag, is a fascinating case. Georgia Democrats in charge of the Georgia government, seeing their power slipping away, say, we got to gerrymander aggressively. Among other things that they do is unpack several majority-minority districts. The political alignment in the case is fascinating because the Bush administration's Justice Department, it's that Ashcroft, says, we're not going to pre-clear this thing because you're not adequately protecting African-American voting strength in the state of Georgia. Goes up to the Supreme Court. O'Connor, in this case, tells them, you can pre-clear that thing. That is good enough, that plan is good enough, even though it diminishes the number of majority-minority districts, because it is still possible that black voters will be able to elect representatives of choice from coalition districts. And even if they can't, there are lots of ways to participate in the political process, and electing candidates of choice shouldn't be our sole measure of how to do that. For reasons we won't go into, Congress overturns Georgia versus Ashcroft in 2006 in the reauthorization, and of course, we know that reauthorization is going to get struck down by the Justice Department, by the Roberts Court. Okay, this is my favorite case. 3 years after Georgia versus Ashcroft is Lulock versus Perry. This is a Texas partisan gerrymander, racial vote dilution, racial gerrymander. It's a great case to teach because every one of the doctrines is in play in this case. You may remember this. This is when the Democratic caucus runs away from Texas to try and prevent the Texas legislature from getting a majority because the Texas Republican Party found itself in 2003 in control of both houses in the governor's office and decided, you know something, even though we have a new districting plan imposed by a court for the next decade, we don't have to wait till 2010 to redistrict. Let's do it now, redistricting. And the numbers that are and it's a huge partisan gerrymander. Just to give you an idea, to get back at the Democrats for decades of Democratic gerrymanders. In 1993, there were 9 Republican congressmen in the state of Texas out of 30. By 2002, Texas got 2 additional seats. That number had risen to 15 under the initial plan. The redistricting plan takes that 15 and makes it into 21 seats. So this shift of political power to the Republican Party. The party does so, or the legislature, I should say, does so. Can I do this? Yes, look at this. This is one of the big things it does. It removes, so this district is District 25. And it links City of Austin. There you go, that gives you a little better. City of Austin, it's a majority Latino district, City of Austin down to McAllen at the border. And Texas draws this district because it thinks it's required by the Voting Rights Act because the big brown district, District 23, ooh, I'm in trouble, I'm not gonna finish. Texas throws 100,000 voters out of the city of Laredo to shore up a Republican incumbent in District 23, the big brown district, who was not getting support from Latino voters. And the court said how it needed to, so it shored up, made the district more Republican and drew District 25 to compensate for that. Supreme Court, now I'm going to just rush in a terrible way. I've already talked too fast. Court says Texas violates the Voting Rights Act. Violates the Voting Rights Act in District 23 because it took away Latino voters in Laredo's opportunity when they were poised to exercise it. And it's a remarkable opinion from Justice Kennedy in which he talks about the Latino community as cohesive, politically active, poised to elect their candidate of choice, and this notion that Texas swooped in and changed the process. And one of the things that I think, and this is going to be way too short now, one of the things that I think is so interesting about Laredo is the court's or Kennedy's focus on a minority community's political participation as being of value and something worth protecting, and that that Section 2 of the Voting Rights Act ought to be construed to do that. It's an approach to Section 2 that focuses more on process than an outcome. And I thought at the time that it showed a possible way out, a path towards understanding Section 2 that might be more palatable to a court that had shifted away from the premises that Justice Brennan had articulated. Okay, but then we get John Roberts, who is on the court at this time. LULAC is one of the first cases that he sits on, and there he looks at what's going on, and he famously says, I'm on the wrong page, it is a sordid business, this divvying us up by race. And to do 10 years of the Roberts Court in 30 seconds, he pursues that agenda. And the notion that communities of color might, as communities of color, be entities worth protecting, not just individuals who might be harmed by expressive uses of race, but as communities, is something that this court loses. There's a North Carolina case called Bartlett versus Strickland, which dramatically narrows the potential reach of the Voting Rights Act. There is, of course, Shelby County, which strikes down the coverage formula, renders Section 5 inoperable, because there is no more formula to have it apply, because discrimination is no longer bad enough to require this remedy. Within hours of this decision, jurisdictions begin enacting provisions that would have been blocked by the Voting Rights Act. Texas resurrects the voter ID that had been specifically blocked. Districting plans and other things are put into place. We have a new fight. I'm going to stop in just a minute. There's a new fight about the scope of Section 2, which comes in now as the only device to challenge these provisions. And so there's a more heated conversation about what Section 2 should reach. Some in my last slide, I had more I wanted to say, but I'm going to, and I'll just be super negative in the end. I have no confidence in this court and this Chief Justice to read Section 2 in a way that's consistent with Congress's aspirations in 1982 and the conception of what racial vote dilution is or should be. And I think that is a tragedy. So I'll stop there. Oh.
I'd just like to remind the audience that if you have questions for the speaker, you can enter them at tinyurl.com/askjerry, or raise your hand and we'll get you a slip of paper to write them on. Dr. Katz, can you say more about why the judiciary has been anti-proportional representation?
Yeah, good question. I mean, Congress is as well, and these are sort of certain premises that I think you go to Germany and they look at us like, what are you guys doing? It's something we're sort of hardwired against. I think for the courts, there's a specific answer, which is number one, the Voting Rights Act says it's not about proportional representation. So as a construction, one might say that the court is precluded from reading the Voting Rights Act to authorize that. As under the Constitution, comes back to Gamillion and Baker versus Carr and this reluctance to read the Constitution as mandating something. Is proportional representation inconsistent with the Equal Protection Clause? I don't think so. Does the Equal Protection Clause mandate proportional representation? That is a hard one to claim, whether you're claiming it based on race or party or any number of things. And that's actually the challenge in the partisan gerrymandering cases right now, to see whether you can look in the Constitution and say this practice or that practice violates the Constitution, because the Constitution itself, the Equal Protection Clause, says we ought to have proportional representation. So.
What are some of the other more creative remedies for racial vote dilution other than majority-minority districts?
Great. So, I mean, I think there's hokey kinds of things like cumulative voting and things that's going to be hard to sort of implement on a larger scale. But you can actually have at-large elections with other devices, not with majority vote requirements, with single-shot provisions. So, for instance, if a jurisdiction, there are 5 people running for the city council in the at-large district, you get 5 votes. You could put all your 5 votes on one candidate, or you could just throw out 4 of your votes and only vote for the candidate you care about. These are devices with a well-informed electorate that a minority group can find expression without having to be a majority in a single-member district. There are ways that this can be done. I don't actually think there's anything wrong with majority-minority district apart from the antipathy that many people feel towards them.
How difficult is it to place jurisdictions back under pre-clearance requirements using Section 3C of the Voting Rights Act? Okay,
I'm going to let Megan answer that question next. Difficult. The Texas litigation is ongoing, and we'll see how that happens. The amount of resources that need to go into it are huge. Unclear whether those will be successful. And part of that is one of the tragedies, I'll say it again, one of the difficulties following Shelby County. What Section 5 did was it froze practices in place and put the burden on jurisdictions before they could make changes. Section 2 cases are huge and expensive and time-consuming, and to get the violations established and then to impose preclearance thereafter, it's not going to ever replicate the kind of system we had previously.
Could you specify what Section 3C says for the audience?
I don't have the language offhand, but it's a bail-in provision where jurisdictions, where courts adjudicating a Voting Rights Act might say there's systematic constitutional violations here. We're going to put you under coverage of the Voting Rights Act, sort of reinstitute, use it to sort of, now you have to get preclearance before you make any changes. It was part of the original act. It was used to pull a limited number of jurisdictions under, to subject them to the preclearance requirement. Since we don't have a coverage formula anymore in the wake of Shelby County, the thought is that maybe case by case, individual jurisdictions could be bailed into the provision.
What was the actual intent of NC 12, since you said ostensibly to comply with the Voting Rights Act?
Incumbency protection. So yeah, it's a crazy shaped district. The Justice Department didn't say, go draw a crazy shaped district. The Justice Department said, draw another majority-minority district. North Carolina says, well, if we draw the district you want us to draw, another Democratic incumbent's gonna run into trouble. We're gonna protect our incumbents. Let's draw this district instead. So it was ostensibly, it was to get Justice Department preclearance, but it was not the district the Justice Department asked them to draw.
How do you think people at this workshop can best help?
So I'm less optimistic than lots of people. I hope you can help. I don't know. I don't know. I mean, is there a formula to have less partisanship in districting? I think everybody agrees that would be a good idea. I'm wary whether the courts are ultimately going to be the institution that's going to be best suited to bring about the change that that many of us think is necessary to have representative institutions that are more representative, whether proportional or not. So I think there's more promise from political solutions in terms of voter initiatives and commissions that would redistrict and take the districting process out of the, away from the folks who in many states, I'm from Michigan, the legislature that draws it there. We are a purple state, but our legislature skews very Republican. That there would be political solutions. Lobby for those.
Robert's best way not to discriminate on the basis of race suggests a lack of familiarity with sociology of race, racialization, racism. Is there any opportunity to change legal standards around race to be on a firmer empirical basis?
I'm not sure. Should just read that last part again?
Is there any opportunity to change legal standards around race to be on a firmer empirical basis?
I'm not sure what that means. I think there is a view, the Rehnquist court tolerated quite a lot of race-conscious districting. It didn't like the majority-minority district, but actually in a slew of cases was willing to say, you know what, you need to consider race here. I think the Roberts court, I think I'm not gonna answer this question, the Roberts court is really hostile to the use of race wherever it finds it. Will strike it down. The way to stop discriminating against race is stop discriminating on the basis of race, says something that's ultimately incompatible with the Voting Rights Act and incompatible with the premise of Section 2. I talked about communities worth protecting, but you can't decide, you can't evaluate whether an electoral practice results in a denial or abridgment of the right to vote and that minority voters have less opportunity to participate. You can't answer that question without thinking about race. You can't be race neutral because you're going to make a mistake, even if you're not ill-intentioned. And I think the Roberts Court, Justice Thomas before that, say, do not think about race, and that there's something immensely destructive about considering it. So I don't know. Is there a way to persuade them? I thought the record was not bad in 2006. Read Justice Ginsburg's dissent. She went through. There was evidence in that record of intentional racial discrimination documented in jurisdictions that were subject to the coverage formula being screened, and yet we saw all sorts of things. And Roberts looks at that and said, yeah, yeah, but it's not as bad as Alabama in 1965, so we're done. I don't know what to do with that. So I don't know how to persuade. I don't think you're going to persuade them. I think you got to elect somebody else to put somebody else in on the court. And that looked different last year than it looks right now. Sorry, that's even more negative.
How can Congress rewrite Section 5 to challenge or overturn Shelby v. Holder?
Yeah, that's a tough one too. And I probably won't have time to go into this. Shelby County was a bizarre decision because there was a legal challenge. The legal challenge was really based on the notion that Congress doesn't have enough power under Section 5 of the 14th Amendment to enact this provision. And there's a long doctrine from the Rehnquist Court, starting with a case called City of Burney, that says Congress needs a record of rampant racial discrimination or rampant constitutional violations before it can enact a statute. And what was once, back in the Warren Court, expansive, really almost plenary congressional power to do whatever it wants when it's enforcing civil rights, gets significantly narrowed into a power that says Congress can only do quite limited things. Shelby County kind of goes off the rails and doesn't talk about this doctrine at all, which was shocking to many of us who spent lots of time thinking about an argument based on this and how the statute might survive that kind of inquiry. I don't know. If you want us to live in the belief that Congress wants to do something about that, does Congress have the power? Is there a record of rampant constitutional violations sufficient to create something? I'm not sure. Then again, look at North Carolina and the findings of the Fourth Circuit in the North Carolina Omnibus Election Act that was struck down by the Fourth Circuit last year based on intentional racial discrimination. Look at the findings of the district court in Texas about voter ID and districting. There's stuff going on. I mean, there's sort of a license. So I don't know. Maybe there could be a record that could be assembled at some point.
Perhaps a hard one. What are you optimistic about?
All of you, that you're all here working on this and thinking about this, I think that's amazing. Godspeed to you. I don't know, I gave a talk last year right after the election, and there was senior citizens in Ann Arbor, and they asked like what we can do, and I said, build a bunker, and that didn't go over well. You should support, what am I optimistic? I'm optimistic about the mobilizations on the ground. My students, their engagement, their willingness to go out and work and lobby and try and make changes. It's gonna be a long battle. It's a battle that's different than it looked a year ago when there was a moment of thinking actually that the court might shift and develop a doctrine. See, I'm going negative now. Develop a doctrine that was more consistent with our values. But if the court's not going to do it, there needs to be fights elsewhere to push in ways that progress can be made. I don't know. That's optimism from me.
Professor Katz, thank you so much.
Thank you.